sentencing today in State versus Cannon, 2025 100725 CFDB. And would counsel again state your appearances for the record, starting with the state?
Ashley McCarthy for the state.
Michael Lambert and Brian Lambert for the state.
Okay. And Mr. Cannon is with us as well. I did review some additional records. It's jail medical records that the state sent over, and case law as well that the state had sent over. I additionally reviewed the case law that was provided by the defendant at the last hearing, and I told you all that I would give you a few more minutes today for argument if you wanted to take that time. And so I'll start with the state.
Yes, Your Honor, just to kind of review what we did on Friday, we had argued about the injury points. I provided that case law to Your Honor. Those were the cases that I had cited regarding judicial fact finding, kind of giving you a definition of slight, moderate, and perhaps severe, but really that it is by discretion of the court. It's an abuse of discretion standard. Regarding any departure, it is I just want to make sure I've got this right, that they are moving for departure pursuant to an isolated, unsophisticated event for which he shows remorse, and that he's amenable to treatment, specifically I think the anger management, I'll let that put that on the record, that he's amenable to treatment. And for those two reasons, they are saying that they are able to, Your Honor would be able to depart if Your Honor put the victim injury points on there.
My understanding was, in addition to those two, there was mention that I should consider the behavior of the victim, which could potentially go to the third grounds for downward departure.
So, and that's what I'd like for the defense to clarify, Judge. They made an argument about that. I don't know, and perhaps they can point out what evidence they have of that and what case law would support that. The state objects to that. I believe Your Honor can depart pursuant to isolated, unsophisticated, for which he shows remorse. Again, we object to a departure that you should not depart. I believe that you can depart pursuant to that he is amenable to treatment. However, I object to that. I don't think that you should depart for all of the reasons that I stated on Friday in my argument. Pursuant to that last mitigator, and that's what they're arguing, I disagree. I do not think, number one, that there's competent substantial evidence of that, and number two, I do not think that there's case law that supports that, so I don't think that that's a ground for departure.
Okay, thank you, ma'am.
And the last thing, Judge, they had kind of insinuated, there's no evidence of this, but insinuated an argument that Mr. Cannon was not receiving proper medical care in the jail. He had been there about 2-3 days on Friday when they addressed that. And I'll let them address that, and I can rebut that if needed. But again, I don't know if that's a movement for some sort of departure or what exactly the purpose of that argument is. But if it was something for departure, there needs to be actual evidence of that on the record that I would then rebut.
Okay. All right, Mr. Lambert.
Morning, Your Honor. Yes, it is that he is one of the reasons that he's amenable to treatment, and that they don't offer that specialized treatment in the prison. They only offer it outside. One of the downward departure reasons that treatment would be for mental health, not just anger management. Either explosive disorder or PTSD, depending on what they end up figuring out the mental health issue is. So yes, that is one of the reasons that she instigated. With regard to the slight evidence on that, that's all in the medical records that the court reviewed in the videos. It's just that attitude. It's not something that we're doubling down on, just pointing out. With regard to the case law and the points, Judge, the Lindy State case, Lynn had told the officer that he bit that he was HIV positive. That caused a huge issue with his mental health, with his family's health, with all of it. So it's kind of disingenuous to use that case as a comparator, but we do agree that it is within the court's discretion, but we do not believe it's moderate. But even so, the state does it sounds like the state agrees that there is a reason the court can downwardly depart if the court chooses to downwardly depart. So we would ask the court to downwardly depart and make it a treatment-based probation where he can get the help he needs. Thank you, Judge.
All right, thank you. And Mr. Cannon, would you please stand up with your attorneys? So I do agree with the defense that permanent disfigurement doesn't always necessarily mean moderate injury. I don't find the Lynn case, or the citing of the Lynn case by the state, to be disingenuous. I think it is helpful. And in that case, the court pointed out that scarring, along with the potential HIV issue in that case, was enough for moderate injury points. And I do think moderate injury points are appropriate in this case here. And I think that that's within my sound discretion to decide. And the reason for that, the reason I'm making that decision is Ms. McCree has a 1.5 to 2 inch scar right across the center of her forehead. She had 7 stitches for that. And then I think we're 7 months after the injury when she sat here next to me, just a few feet away from me. It's glaringly obvious, and that's something she's gonna have to live with unless she gets plastic surgery to get rid of it. But it's red, it's raised a bit, and it's readily available to anybody who looks at her, readily visible. So I am scoring the moderate injury points. That unfortunately means that the defendant scores 19.1 months DOC unless I find grounds to downward depart. Obviously this is a tough case, and let's talk about the grounds for downward departure. And I saw Mr. Lambert nodding his head when I was saying that I thought one of the grounds was that the victim, Ms. McCree, was somehow an initiator or provoker of the injuries that were caused to her by the defendant. And I've watched all of the videos. Ms. McCree was highly intoxicated. She was verbally abusive. But that's your job in law enforcement, to deal with all sorts of people, including people that are hostile, verbally abusive, and highly intoxicated. She was, in fact, screaming and combative at the hospital and had to be given medication and restrained, as your attorney argued. That was after the injury, though, after she had lost a significant amount of blood and had this huge gash across her forehead. I don't find that there's grounds to downward depart. I don't think that that has been proven, and I don't think it would be appropriate even if it had been proven. Unlike the state, I don't think that this was committed in an unsophisticated manner. I do think it was an isolated incident and the defendant's shown remorse for it. But the reason I'm finding that it wasn't committed in an unsophisticated manner was because after the victim was injured, she was placed in a holding cell. I think ignored, as best I could tell. Nobody attempted to tend to her or give her any kind of aid. And then there were lies to the supervisor about how it occurred. So I don't find that that was committed in an unsophisticated manner. I do agree with the state, though. The defense has proven that the defendant suffers from a mental illness that's unrelated to substance abuse or addiction, and the defendant is amenable to treatment. One of the mental health providers, I think, saw the defendant, it looked like only one time, and diagnosed him with PTSD based solely on his 7 years in law enforcement. I'm disregarding that opinion. I think that that opinion it is not specific to the defendant. The other treatment was more ongoing. It started in January and continued through June. There was a diagnosis of intermittent explosive disorder, and I find that that is appropriate under the circumstances. I do find that you suffer from a mental illness that's unrelated to substance abuse, that you are amenable to treatment. I am going to consider, in addition, your lack of any criminal history whatsoever and the 7 years of public service that you've done through your job. And I want to be very clear, I am not downward departing because you are a police officer. I am downward departing because you have no criminal history, and I'm trying to treat you the same as I would anybody else under similar circumstances in a similar situation. So I am going to adjudicate you guilty. The reason for that is, as a convicted felon, you will not be able to own a gun, buy a gun, possess a gun, and that's important to my sentence. I'm going to sentence you to 6 months county jail. Madam Clerk, how much credit does he have?
11 days.
Okay, you have 11 days credit. That's going to be followed by 2 years of probation, during which time you need to undergo a mental health evaluation and any recommended treatment. You will be required to surrender your law enforcement certification to the state of Florida, but I believe you've already done that, sir. And then I am going to order restitution to the victim, Ms. McCree. I'm going to reserve for 60 days to determine that amount. And so if it wasn't already done, Madam Clerk, I'm going to revoke his bond today. And then the court costs are $770 plus 100 costs of prosecution, 100 costs of investigation, and that'll be a condition of your probation as well. Like I do with everybody else, I'm going to waive your cost of supervision for 1 of the 2 years of probation. And that's to encourage you to try to complete the terms of the probation and terminate early at that halfway point. Your attorney knows that you can file a notice of appeal within 30 days of signing the judgment and sentence. And then the other thing I wanted to mention is that any of the items that were submitted and taken into evidence are public record currently, and defense may want to consider whether to seal the medical records. Okay. Anything else the court needs to address today?
No, Your Honor.
Okay. All right. Thank you, folks.
Thank you.